All right, let's get started. Today, we're diving into one of the most powerful and, frankly, heartbreaking articles of the Indian Constitution, Article 7. Now, this isn't just some dusty old legal rule. It's a direct, powerful response to the chaos of the partition. So let's really unpack what it says, and more importantly, what it means.
Here's our game plan. We'll look at the massive problem the partition created, then get into the nuts and bolts of Article 7, the absolute rule, and the one tiny exception. We'll see how the courts handle it, and then I'll give you the final review to make sure it all sticks.
So just try to imagine the scene in 1947. A line is drawn on a map, and suddenly, millions of people are on the move. It's absolute chaos. And for the framers of the new Constitution, it created a legal nightmare. They had to ask a fundamental question. In the middle of all this, who exactly is an Indian citizen? And that brings us to the sharp end of the stick. Let's put it bluntly. What about someone who was born in India, lived in India, but then, after the new borders were announced, decided to move to the new territory of Pakistan? Are they still Indian? That's the exact critical question Article 7 was written to answer. So what was the answer? Well, the Constitution didn't mince words. Article 7 drew a very, very firm line in the sand. Just listen to that language. It's so decisive. It doesn't say you might lose your citizenship. It says you shall not be deemed to be a citizen. That's it. It's like a legal guillotine. The moment the law saw you migrating to Pakistan after that specific date, bam, your claim to Indian citizenship was cut off, cleanly. Now here's where Article 7 gets its real teeth. These first few words, notwithstanding anything, this is what lawyers call a non obstante clause. Think of it as the ultimate trump card. It means I don't care what any other rule says. So even if you met all the criteria for citizenship under Article 5 or Article 6, it doesn't matter. Article 7 swoops in and overrides them completely. It's the boss. Okay, everyone, listen up. If you remember one thing from today, make it this date. The cutoff is March 1st, 1947. This is a classic exam trap. People always assume it's August 15th, the date of independence. No. The line was drawn months earlier. Burn the state into your brain. March 1st, 1947. So you're probably asking, why that specific date? Why so early? Well, the framers were realists. They knew that the partition wasn't just an event on August 15th. The mass movements, the violence, the de facto separation of communities, that was already happening. The country was already splitting apart. This date was chosen because it reflected the grim reality that was already happening on the ground. But in law, for every harsh rule, you should always hunt for the exception. And Article 7 has one. It's called the proviso. And it was the only very narrow lifeline for someone who had gone to Pakistan but had second thoughts and wanted to come back. Now, this was not a simple welcome back situation. Not at all. It was a bureaucratic obstacle course. First, you had to return. But, and this is the key, you couldn't just show up. You needed an official permit for resettlement. Once you got that golden ticket, you were then treated like someone who had come from Pakistan after July 19, 1948, which meant you still had one more hoop to jump through. You had to get yourself officially registered as a citizen before the Constitution came into force. You miss any one of those steps, and the door was shut. Okay, so we've got the text of the law, but as we know, the real meaning of a law is forged in the courtroom. So let's see how the Supreme Court handles Article 7 when real people's lives were on the line. These two cases are just perfect. They show you both sides of the coin. In Izhar Ahmad Khan, the Supreme Court brought the hammer down. It declared that yes, Article 7 is an absolute bar. The door is slammed shut. But then, in Shano Devi, the court showed that the window was still open. It confirmed that if you followed every single step of that proviso, got the permit, got registered, then yes, the path back to citizenship was real. And here is your cheat sheet. Look at that 5-star rating next to Izhar Ahmad Khan. If you are ever asked about Article 7, this is the case you have to cite. It's the bedrock, the leading authority that cemented the absolute bar interpretation. And don't forget Ibrahim Wazir Mawat, which was crucial for saying that migration wasn't just moving. It was about making a conscious choice. All right, let's land the plane. Time for a final review to lock in the most important points. This table is fantastic because it shows the beautiful symmetry in the law. See how Article 6 deals with people coming from Pakistan and Article 7 deals with people going to Pakistan? They're perfect mirror images of each other, designed to handle the two-way flow of people during that chaotic time. Understanding that relationship is absolutely key. When you strip away all the legal language, all the dates, all the clauses, you're left with one powerful, simple idea at the heart of Article 7. And it's this. Citizenship follows choice. The framers' logic was that the act of moving to Pakistan was a deliberate choice to align with a new country, and the legal consequence of that choice was giving up your claim to Indian citizenship. So, let's do a lightning round. 1. Article 7 trumps Articles 5 and 6. 2. The date is March 1st, 1947. 3. The proviso is the one way back, but it's tough. And 4. Izhar Ahmad Khan is your go-to case. But let me leave you with a thought that goes beyond the exam. Take a step back and think about what a law like this really means. What does it tell us about how a brand new nation, born from trauma, decides who belongs?